morning. Welcome to the 21st MCA webinar. Today you've got Rachel Wilkinson, Joe Myers and myself. How do I move the next slide on, Rhiannon? I can't see a thing to move it on. Just a bit of housekeeping to start with. Please do get involved. Use the Q&A and ask questions or make comments, and we'll try and pick those up as we go through, or if we don't have time we can possibly come back to some at the end. If we still don't have time to pick up all the questions, hopefully we can send something out later. This webinar is being recorded, just so that you're aware. Now at the very end we'll be asking you to do an evaluation, and the evaluation, once you've sent it in, will produce your certificate of attendance. Sometimes people have problems with the slides or the sound. If you try leaving and signing out and signing back in again, that sometimes, well, that quite often just resolves it. I've just had to do that myself actually. If you still can't do that, try the MCA number there, and somebody might be able to help you get back in. And the next slide. Okay, so I'm just going to run through the aims of this session. So we're going to talk about objections today, and we're looking at that in the terms of deprivations of liberty. The aims of the session are to help you decide whether a person's objecting to their care and support arrangements. So this is a tricky area. We get lots of questions about it and lots of people ring. So we're going to look at things like how we interpret behaviour, and if we do think we've identified an objection, when an application to the court protection may be appropriate, and responsibilities within those care and support arrangements for things like identifying objections. Next slide, please. We're going to be looking at across the board, so people living in their own home, including things like use of technology, people living in nursing homes, care homes, and their right to appeal to being placed there. And, you know, looking at whether the objection is reasonable or whether it's unachievable, and then what do we do if we identify that the thing the person's asking for isn't achievable. We're also going to be looking at hospital cases and when somebody may not be eligible for doles, I think. Although we won't go into that in any detail today, because we're mostly looking at objection in care homes and people's own homes. Next slide, please. Can you move it on, Rhiannon? Or thank you. So looking at the acid test, which came out with the Cheshire West judgment in 2014, we're talking about when somebody is deprived of their liberty and they meet those specific criteria that came out in that, you know, they're not free to leave, they're under continuous supervision and control. I'm sure you're all familiar with those. Now, before we had Cheshire West, we had to kind of consider whether the restrictions amounted to an objection, and when we look ahead at LPS, you know, we might have to sort of think about that a bit more again. So but Cheshire West brought in the acid test, and it told us that if a person was compliant or non-compliant, if there was a lack of objection, we might still find that they ought to be their case ought to be taken to court, and Joe will go through that, and so will Rachel in a bit of detail. The relative normality of the placement was something we used to look at, and the reasonable purpose behind a particular placement. Well, Cheshire West sort of swept all that away, but looking ahead to LPS, we just thought we'd mention that in these terms. I'm going to introduce Joe Myers now, and she's going to talk through a little bit more about the case law that came in that told us a lot more about what an objection is and when we go to court with it. So handing you over to Joe.
Thanks, Val. Can you move me on, Rhiannon, please? Thanks. So as Val was saying, I'm going to be looking at AJ, and Rach will look at the other piece of case law on the screen. You can see that AJ was heard in court in 2015, and it's an extremely important judgment from Baker J. And in that judgment, he gave us detailed guidance as to the heavy burden that is placed upon local authorities in making sure that everyone that's deprived of their liberty, and at that time, and as it still stands now, that's in care homes and hospitals. And it was about making sure that they were afforded effective access to the Court of Protection as to secure their rights under Article 5 of the European Courts of Human Rights. And that's the right to liberty, Article 5. And here at the MCA team, we felt it was really important with LPS coming that it's going to be everybody's responsibility to be able to identify if somebody is objecting to their package of care or their restrictions in their home or a care home. It's going to be down to us as frontline practitioners to be able to identify that and then what to do with that once we have identified it. So I'm going to give you a brief overview of AJ. And she was an elderly lady, and she had lived for a considerable period of time in the annex of a home of her niece and her niece's husband, and they were known as Mr. and Mrs. C. AJ had developed vascular dementia and had become increasingly dependent on others, in particular Mrs. C. Unfortunately, AJ was reluctant to acknowledge her condition and was absolutely insistent that she could manage without any help. So in April 2013, AJ signed a lasting power of attorney in respect to her health and welfare and property and financial affairs, and in that document she named Mr. and Mrs. C as donees. Around the same time, AJ was referred to social services by the psychiatric nurse. When a local authority case coordinator visited her on April the 22nd, Mrs. C raised the possibility of respite care for AJ to prevent the breakdown of the care arrangements. In June of the same year, so 2013, Mrs. C made it clear that she could not continue in her caring role in its current form, and she advised that her and her husband were planning a fortnight's holiday. She said that she now felt that permanent residential care was required. The local authority social worker offered to find the nearest suitable home for respite, while Mr. and Mrs. C were away, and she identified home X house, it was known as. So she identified X house for the purposes of the respite. It was clear that Mr. and Mrs. C hoped that if AJ settled, that she would remain in the care home on a permanent basis. And that's something really to be mindful of. It isn't really respite if you think, if the family are saying, well, actually, we're probably not going to have her back, or, we're hoping she'll settle. That needs to be considered and documented, your views about that, because it's not respite then. So on the 13th of June, and just before they went on holiday, Mr. and Mrs. C took AJ to X house, and upon arrival, she stated that she didn't want to be there and repeatedly asked to leave. Now, in this case law, it says that no assessment under Schedule 1A of the Mental Capacity Act had ever been carried out prior to her arrival. So that when DOLS came in, it was hoping that all people that moved into care homes, that there would be an authorised, a standard authorisation in place prior. So in this case, they're saying that didn't happen, but the managing authority requested an urgent authorisation. It was a DOLS assessment was carried out, and a 21-day authorisation was given because they said that the situation, it seemed a bit unsettled, so their 21-day authorisation was in place. And Mr. C was appointed as a RPR. Now, anybody that has a DOLS in place, I'm sure you all know this, are entitled to a relative person's representative. And for this purpose, Mr. C was appointed. Now, it says here that Mr. C was appointed as AJ's RPR on the basis that AJ had a donee who, under the RPA, permitted them to select a family member, friend or carer for their RPR. that donee had selected Mr. C. So the RPR, so the DOLS assessor selected Mr. C to act in as the RPR. It was at this stage that Mr. C that supported AJ continuing to be accommodated in the home. So it was very clear that Mr. C supported his wife and felt that actually permanent placement was required now. When we appoint a family member as the RPR, they are automatically supported by what we refer to as a Section 39D IMCA. And that's somebody that will support them to take a challenge to the courts if it is required. So the family member could still be the RPR, but the 39D IMCA could support them. So Mr. C was appointed Mr. R as a Section 39D IMCA. At the start of July, so at this point now, she's been in the home since June. So at the start of July, AJ was moved to Y House and she's remained there thereafter, subject to repeated standard authorisations. Despite AJ's known opposition to living at Y House, no legal challenge was made to the standard authorisation for several months. And this is where Baker J has noted the reason for this failure lies at the heart of the case. It's critical. A critical reason was the lack of effective communication between Mr. C and Mr. R. So we knew that Mr. C knew that AJ was objecting to her placement. And because his views were that she should remain there, he didn't seek legal advice to take a 21A challenge. It would appear that Mr. R didn't really communicate with Mr. C, so poor AJ remained in Y House for some months with nothing happening. When Mr. R finally did speak to Mr. C in the November of that year, the 39D IMCA realised that Mr. C was not going to initiate proceedings, and after further conversations with his manager, he agreed to act as the litigation friend and instruct solicitors to make an application to the court. Proceedings were eventually issued in December, challenging the standard authorisation made in July. So poor AJ remained in that placement, despite her being very clear at the beginning of the placement that she didn't want to go into placement, and then when she was there, nobody did anything. And what Baker J has said is that there is a positive obligation on the state to protect the liberty of those within its jurisdiction. Otherwise, there would be a sizable gap in the protection from arbitrary detention. There would be inconsistence with the importance of personal liberty in a democratic society. The state is therefore obliged to take measures providing effective protection of vulnerable persons, including reasonable steps to prevent a deprivation of liberty, which the authorities have or ought to have knowledge. So this is why we felt it was really important, because that still stands. It will be down to us as practitioners to identify an objection. He goes on to say that there is an obligation on the state to ensure that a person deprived of their liberty is not only entitled but enabled to have the lawfulness of his detention reviewed speedily in court. Baker J gave us a list, a really helpful list to help RPRs in this case, but I think it's useful for us all to know that, or to know this list. That might help us identify if we can see an objection. I think we might have a bit of a delay. Okay, so to decide if P's behaviour constitutes an objection, we must consider what's the possible reason for P's behaviour. We need to think about, is there maybe a UTI? We know that sometimes can make people's behaviour change. Affection of any other sort, maybe constipation, a recent change in their routine. Has something happened different that's really thrown them? Death of a close family member. If they've lost somebody, has due consideration been given to the emotional effect that might have on them? Other external influences, new staff, new residents that have caused them some distress, or now walking into their bedroom, or just noisy. So we need to give due consideration to the possible reasons for that behaviour. We need to think about if they're being medicated for depression, or they're being sedated. You need to question why. Are they being sedated or medicated because prior to that they were walking around, trying doors, unsettled, showing a clear objection? They're not doing that now because actually we've sedated them, or the doctor or somebody has sedated them. Are they using equipment like a tilt and space chair to stop people from moving around? We need to think about that. Is Pete actively trying to leave the care home or hospital? Are they packing bags? Are they trying doors? Are they trying to climb out windows? We'd also ask you to consider that they might not be able to actively leave, but is their behaviour suggesting that that's an objection, not accepting care, pushing people away? So again, think about that. Are they taking steps to leave, e.g. packing a bag, standing by the door, those sorts of things? What's their demeanour and relationship with staff? Are there some staff they like better than others, or do they not get on with any of the staff? Do they not want to have carers helping them? Are there any records of challenging behaviour, and what were the triggers for that? So have a look through the ABC charts, have a good look through everything that's there, and think about, what's triggered this? Is it the same carer? Have a good look and think about that as well. And is Pete objecting to any particular aspect of their care arrangements, or are they objecting to everything? So is it in the whole, or is it just when they're having personal care, or just when they're having a bath? Or so I think, is it just one thing, or is it just everything? Are they just generally unsettled in their care home? So there are some things you could also think about. So has the person ever have they ever said about starting proceedings? Now some people might like capacity to say, yes, I want to take it to court. However, recently I was assessing a gentleman who didn't say to me, I want to take this to court, but he told his wife, he blamed his wife for being in the care home and said, I'm going to take you to court. So Baker J's asked us to think about any statement made by P about his wishes or feelings in relation to issuing proceedings. So we need to think about that. Any statement made about residential care? Had they ever told anybody they didn't want to be in residential care? That they've never wanted to go into a care home? And that could be to the BIA or to close family members, or you as the worker. What's their emotional state like at the moment, and does this fluctuate? So we need to think about that. The frequency, how often are they asking to leave? And that links back to that, is it particular aspects of the care arrangements, or is it everything? Are there any alternative reasons for their express wish? And that's, again, think about the possible reasons. So these are some of the things that Baker J asked us to consider. So as practitioners, we're asking you to think about that. If you've got somebody in a home and there's a significant package of care going in, are they showing any of those things from the list that I've just gone through? Are you seeing that, and would you think that that would be an objection to their care? Because if you do, we would suggest you give us a call and we'll talk it through with you, or you speak to legal and you ask their advice there. So could you just move on? I think I'm going to hand over to Rachel now, who's going to talk a little bit more about the RED and the others, which came in 2016. So over to you, Rach.
Hi, sorry, I just realised I was on mute, so just starting again. So hi, I'm Rachel. It's really nice to be here with you this morning. Thanks, Joe, for handing over. I'm just looking at RD and others this morning from 2016. So this is involving 5 test cases involving elderly people. So RD, JB, JP, EP and JW, who all suffered from a form of dementia and were identified to enable the court to consider the question of when an application should be made under Section 21A of the Mental Capacity Act. So this case law just gives us some really good guidance on the objections and how to identify that. So see if I can move on. So just having a look at each of these cases and what their background was and what led up to this point. So RD had a lifelong presentation of mental and physical disabilities with a historic diagnosis of chronic schizophrenia, although her symptoms were more closely linked to learning disabilities and autism. During the initial stages of her stay, she frequently expressed an objection to being at the care home and a desire to leave, though recently it was reported that she had become inconsistent about her wishes and expressed a fear of moving from the care home. JB had Alzheimer's disease. After moving to the care home, she was frequently agitated, attempted to leave the building, and became verbally aggressive when prevented from doing so. At other times, she requested to leave and thought she had to pick up her children, all of whom were grown up, and she was thinking she needed to pick them up from school. In more recent months, the episodes of agitation had decreased and she was no longer attempting to leave the property. She was engaged more in activities and enjoyed walking around the grounds. JP had a history of physical medical problems and suffered from moderate to severe dementia. On arrival at the nursing home, she repeatedly asked to be allowed to return home. She was regularly distressed and agitated, calling out loudly with repetitive sounds. JP moved to a quieter wing in the nursing home, but once again became very agitated. When her RPR discussed with her the option of bringing an application to court, JP stated that she would like this to happen. EP had vascular dementia. After an admission to hospital following a fall, EP was discharged to a care home. She clearly objected to being at the care home, saying that it was like a prison and that she wanted to return to her own home. The RPR concluded that there was a fluctuation in AP's compliance with the care arrangements and her acceptance of the situation. JW suffered a series of stroke. He consistently expressed objections to his placement at a nursing home. He became more settled and willing to engage with staff and activities, but whenever questioned about his placement, he reiterated his wishes were to return home. Over time, JW increasingly appeared settled, but always maintained his position of wanting to return home. So I think there's all sort of cases that we can identify with and relate to that we might have had similar situations. So there's trying to bring a range of cases for the court to consider. So the question that the court was being looked at in this case was, when, if at all, does the requirement under Article 5.4 to assist P to exercise his or her right of appeal to the Court of Protection under Section 21A of the MCA arise in cases other than those in which P expresses a clear and consistent objection to the arrangements for his or her care and treatment. So I've just highlighted that bit where it says expresses are clear, because what we're talking about here is, you know, some people might be able to verbally explain that they want to leave the care home, but others we're looking at some of those behaviours that demonstrate that, and it's not always clear and verbally that that's what they're trying to say. So this is just the list that Joe went through, so I won't go through it again. This is what come out of RD and others. Some people, when writing their assessments in DOLS particularly, will use these, particularly if they're a bit unsure about whether it is an objection or not. It really helps you sort of break that down and really look at it. There was a case as well, like I was aware of where somebody wasn't able to verbally communicate. So the BIA in that situation was really looked at this list and looked at how they were behaving and whether that was demonstrating an objection. So the list is just there if you need it. Again, on the next slide, oh, it might have gone too far. Again, what Joe looked at, but it's there for you to come back and have a look at if you need to. And like I say, and use that if you need to. And the important thing is to come to a conclusion as well. So look at all this if you need this is a tool to help, and do come to a conclusion whether you're assessing the outcome to be whether that person is objecting or not, because then that's really what we want to know for the doles. So some other information that come out of RD and others was that the RPR must consider whether P wishes or would wish to apply to the court of protection. So this involves the following steps. So consider whether P has capacity to issue proceedings. So I've just highlighted that again so you can see the difference. This simply requires P to understand that the court has the power to decide that he or she should not be subject to his or her current care arrangement. It is a lower threshold than the capacity to conduct proceedings. If P does not have such capacity, consider whether P is objecting to the arrangements for his or her care, either verbally or by behaviour or both, in a way that indicates that he would wish to apply to the court of protection if he had the capacity to ask. So it's just highlighting those differences there. The person might not have capacity to ask to issue the proceedings. So it's the RPR's role to look at whether that person is objecting to the arrangements via verbally or both, and that would indicate that they do still wish to apply to the court of protection. Try and move it on. Oh, I think it's done. Yeah. So this is again out of RD and others. So as Joe explained in the earlier case of AJ, Baker J considered the selection and appointment of RPRs and MCAs and the duty on the local authority to ensure that the person who lacks capacity is able to challenge the deprivation of their liberty. So the onus seems very much on the person there who lacks capacity is able to challenge the deprivation of their liberty. In this case, Baker J concentrated on the question of how the relevant person's representatives, the RPRs, Section 39D MCAs, should decide whether to bring an application to the Court of Protection under Section 121A. So again, it's looking at whether they can identify through that behaviours and things like that, or whether they can help that person to decide whether to bring that application to the Court of Protection. So it's not just on the person themselves. So the outcome in RD and others was that the advice given to the local authorities, which they accepted, that the Section 21A applications have been properly brought in the cases of EP and JW, and the other cases, RD, JB and JP, were referred back to the RPRs for a decision in light of the court's general guidance. So they were asked to relook at those. I'm just going to move on now to have a little look at the MCA draft code of practice and the LPS and what that's going to mean for us going forward. It's very much in the section of the MCAP role and looking at objections there. I've just highlighted a few points that are here that are relevant to do with objections. So the role of the MCAP is to carry out the pre-authorization review of the person's case, and these two first points are the ones that are most relevant here, I believe. So it says it is reasonable to believe that the person does not wish to reside in the place proposed in the arrangements. It is reasonable to believe that the person does not wish to receive care or treatment at the place proposed in the arrangements. So just look at those 2 points for today. We're moving on. Slide seems to be there. It's gone a little bit too forward, I think. It's all right, we're just having a little thing with the slides today, I think. We can go back one. Oh, we both clicked it now, I think. So just looking at with the MCAP role again, so it would be reasonable to believe that a person does not wish to reside in a in or receive care and treatment at a place if the belief is based on the individual circumstances of the case and decisions are rooted in evidence. So it talks about really sort of formulating and collecting that evidence and documenting that to look at that objection. Another point I thought was interesting, it's put it is irrelevant whether the person's wishes and feelings are reasonable or not. The focus should be on the fact that the person does not wish or is perceived to not to wish to reside in or receive care or treatment at the place proposed in the arrangements. And the focus should be on the person's current wishes and feelings. The duty to refer the case to an MCAT would apply even if the person was actively trying to leave the place they live in, even if in the past when they had capacity, they indicated that they would be content to live there. So it's really looking at what is the current situation now and what are they sort of saying or behaving in a way now. So LPS again, I won't go through all this because we've looked at it, but in the draft code of practice, it has pulled through that case law that we've been looking at, AJ, RD and others. And those statements that we've talked about of how you can really look at whether someone's objecting or not. So that's all in the draft code of practice from that case law. Again, it's very similar from what we've talked about earlier, and it's pulled that through. It's just to reiterate as well that concerns that the person does not wish to reside or receive care or treatment in a place can be raised by anyone, including the person themselves or by another on their behalf. So I think it's really helpful for us to just be aware that we all have a duty to look out for, recognise when somebody may be objecting and raise that as a concern. So it could be that somebody's there to do a Care Act assessment, could be to do a review, you could observe somebody else that you feel is objecting, could be a visitor, as we said, it could be anyone that notices something about that person objecting, and we're wanting people to raise that and let us know. So yeah, that's all from the MCA draft code of practice. I'm now going to hand over to Val, who's going to just take us through the next part now. Okay, thanks, Val.
Right, I have unmuted myself, so hopefully you can hear me. I'm sorry, we're having a bit of trouble with the slides today, and I can't see the little arrows to move it on, so I'm going to have to ask Rhiannon to do it when it needs to be moved on. If you can just put it on to the next one, please, Rhiannon. Thank you. So what we've been looking at is objections and what an objection looks like. When we appoint, at the moment with DOLS, when we appoint a relevant person's representative, the RPR, that is something that the RPR should be looking at. They should be looking at whether the person is objecting as part of their role to do that. So it's a very important part of the role, and it's something that we really need to be considering when RPRs are appointed or suggested. So I'm going to go back to why we're looking at this and why we're sort of highlighting this, and we're looking at the Human Rights Act, Article 5, and Article 5 is the one that says everybody has the right to liberty and security of person, and that you can't be deprived of your liberty unless there is a procedure prescribed by law. And 5.4 is that everyone who is deprived of his liberty by arrest or detention, and that includes DOLS. I know when we lump it in with things like arrest, it all sounds, sort of as if it doesn't necessarily apply to people in care homes, but they're still being detained if they're deprived of their liberty. And what it says is that they are entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court. So in the case of AJ, when we were looking at AJ and the length of time it took to take that to court, that wasn't speedily. And that person was being detained for months with no access to a right of appeal. And this is why we're sort of emphasising that we need to be kind of looking out for whether somebody's objecting right at the beginning of when somebody goes into care home, or indeed if they're in hospital. So if you're under, if you are arrested, you have a right to appeal through the courts. If you're under the Mental Health Act, you have a right to go to a tribunal. And for these sort of cases in care homes and hospitals, people have a right to go to the Court of Protection. And that was one of the things that came in with the Mental Capacity Act. The relevant person's representative then is a really important role in identifying objections. So it needs to be given careful consideration. So for all the BIAs out there who are currently BIAs and possibly will be AMCAPs in the future, when you choose the RPR, you need to be asking those questions. Do they realise that actually they're not necessarily doing what the person is, they think is making the person safe, or what they think is in their best interest. What they're doing is advocating, and they have to be that person's voice. So if the person is objecting, and this is why sometimes when you have a family member as a representative, you have to sort of go through, and I know most of our BIAs are really good at this actually, and saying, you do realise that if they're objecting, you will be responsible for making an application to the court. Now, if as Joe was saying, it's actually the local authority's position that they should be doing that if they're aware of an objection and nobody else is taking it to court. But we only do that if we know about it. So if we don't know about it, then we're not aware of it, we wouldn't even know that it should go to court. So the RPR is chosen by the BIA except where the person has lasting power of attorney for health and welfare, and then that person can choose to be the RPR themselves, or they can ask for a different RPR. So when LPS comes in, that RPR role won't exist. So it's going to be an appropriate person instead. Now that is the suggestion is that this will usually be a family member or a friend, and they are going to be appointed to support the person through that LPS assessment process and throughout the authorisation period. So it's going to be even more important that people working in services, in care homes, in hospitals, in social care teams are going to be able to identify when somebody's objecting, because it is more like going to be everybody's business at that point. If there are any questions about what's been covered so far today, we are running ahead of time. We have got time for some questions if anybody wants to ask any. Have we got any more slides after this? I can't even remember, Sorry? Let them finish, yeah. So let's just go on to further information. So we got future webinars. We're changing the dates a bit on the webinars, so keep a look out, because they're not all Tuesdays in the future. We're swapping some of the dates about. So we've got one coming up on Tuesday the 4th of October, Friday the 11th of November, so a Friday one again, and the now traditional Christmas MCA quiz, because we couldn't not do it now. If you haven't already saved the date, the next MCA conference is on the 28th of February 2023. Hopefully you'll all be able to attend. It is going to be virtual again this time round, but we don't know, for the future what will happen there. And as I said earlier, we will ask you to do some feedback so that we know what you want for future topics. And if you've got a smartphone, you can do the QR code thing, or just use the link, and then when we receive your feedback, you get the certificate. So it's a way of us making sure that you give us the feedback, basically. I think lots of people do that now as well. Thank you very much for your time today. It's that is all we've got, and there aren't any questions. So obviously, we covered everything that people had any concerns about. That's not true. Anyway, have a good weekend, everybody. Thank you.